low-traffic neighbourhood, and the Railton and St Matthews low-traffic neighbourhood. The relevant orders have not yet been made.
Right.
It's expected that they will be made during the course of next month, say February 2022.
Right.
In each case, the decision took account of an updated equalities impact assessment, and in each case the decision accepted the findings of the relevant equalities impact assessment, that certain dispensations should be made to the restrictions which would be made permanent by the orders. In particular, that blue badge holders should be given dispensations in relation to restrictions which were local to their place of residence. So in the case of those who live within the area of the Railton and St Matthews low traffic neighbourhood, which I think is the appellant, who lives just off Shakespeare Road.
Right.
Assuming that she is a blue, or either is or is eligible to be a blue badge holder.
Yes.
That dispensation would be available to her.
Yes. Right. Thank you. Is it sensible? I'm just asking this question without knowing what the answer is, of course. Is it sensible to put this down in an agreed note to the court? I mean, I'm not saying that it has any bearing at all on the issues. Whether it does or not, I don't know. But even if it doesn't, it would be helpful just to have an agreed note, perhaps, on the factual position.
Yes.
Sounds sensible to me.
I mean, it can be quite brief, and it can more or less say what you've just said. I've written down in my notebook a summary of what you've just said.
Yeah.
But I think it would be helpful just to know an agreed position, if possible.
Thank you. And I think Mr. Mould made this clear, but just so the orders which have been decided upon but not yet made are in relation to Railton and Oval Triangle, but not Streatham Hill.
That's right.
Yes, no, I noted that it was Oval Triangle
So
and Railton St Matthews, yes.
Yeah.
But not the third one. Not Streatham Hill.
Whilst I'm on my feet,
Yes.
You should have copies of the authority that my lady referred to yesterday.
Yes, yes.
And also the list of the correct supplementary bundle numbers, which I sent.
Oh yes, thank you very much for that. You kindly sent an email earlier about that, I think. And this is the case that, of course, I'm familiar with it, but my lady mentioned through her clerk last evening.
That's right. Thank you.
Thank you for that. Yes. Yes, Mr. Bewley.
My lords and my lady. So, as I said, I think I've done the introduction. So in terms of housekeeping, we've got an authorities bundle, a core bundle, a supplementary bundle, and the only free-floating document, as it were, is one that's already been mentioned, the additional authority, which I'll touch on very briefly in due course.
Yes, thank you.
My lords and my lady, this is my appeal from the order of Mr. Justice Kerr in relation to two claims, claims I should say, for statutory review relating to a number of road traffic orders, which in each case you take them as a package, taking the relevant package you then give effect to low traffic neighbourhoods in three areas of Lambeth.
Yes.
And secondly, a claim for judicial review relating to specifically one of those low traffic neighbourhoods, the Oval Triangle area. That gives rise to some issues about relief, which I'll touch on. I don't know if they're controversial. I don't think they're controversial between the parties, actually, but
Right.
I can say something about them. So the ground on which the appeal is pursued is obviously a single one. It's that Mr. Justice Kerr was wrong to reject the claim based on the public sector equality duty,
Yes.
namely that the council in deciding to make the relevant orders, so far as it did decide in relation to Oval Triangle, where the position is a bit special, we'll come to that, failed to comply with its duties under section 149 of the Equalities Act 2010. And that's the single ground on which the matter is pursued. So the programme of my submissions then is as follows, if it's convenient to the court.
Yes.
First of all, and pretty briefly, nothing turns on it, but it's useful getting under about the general the statutory scheme. under the Road Traffic Act. Secondly, I'll say something about the facts. Thirdly, the law in relation to the public sector equality duty, and then drawing those threads together, my submissions on why the duty was not complied with in this case. So that's the programme I anticipate developing.
Right.
With that in mind then, if I go first of all to the statutory scheme, if we just pick up the authorities bundle, as I say, nothing particularly turns on this, but it's probably sensible just to get the basic framework clear. It's first of all tab 1 of that authorities bundle,
Yeah.
which is the 1984 Act. And we just need to look at a couple of the sections of the Act. Slightly counterintuitively, you might think we need to start with section 1, even though section 1 is headed traffic regulation orders outside Greater London.
Yes.
But we need to pick up on that just to... So that provides for the relevant, subsection 1, the relevant traffic authority for a road outside Greater London may make an order under this section, referred to as a TRO, or Road Traffic Regulation Order, in respect of the road where it appears to the authority making the order that it is expedient to make it for various purposes. I won't read them all out, but probably materially, and there's no argument here that these orders were ultra vires, but materially for our purposes C and D, for facilitating the passage on the road of any other road of any class of traffic, including pedestrians, and D, for preventing the use of the road by vehicular traffic of a kind, etc., which is unsuitable.
Yeah.
So that's section 1, which wasn't directly in play. Section 2 then tells you what, and this is page 7 of the authorities bundle, tells you what a traffic regulation order may do, and it spells out certain things, but restricting regulation, so forth, the passage of vehicles. And then, more pertinently for us, section 6,
Yeah.
this is why we needed section 1, page 13 of the bundle, orders similar to traffic regulation orders, and this is for Greater London. So, subsection 1, the traffic authority for a road in Greater London may make an order under this section for controlling or regulating vehicular or other traffic, including pedestrians, and that can be for various purposes again, which include all of those in in section 1 that I've already shown you. So all of those purposes are legitimate.
So that's B, yes.
Exactly right. Section 6, 1B.
Yeah.
And I think that's all we need. Nothing turns on the construction of these sections or anything of that
No,
nature.
there's no controversy about that.
No. Finally then, just to complete really the picture in terms of the basic powers, we then go to section 9, which is the power that was actually used in this case, which is obviously parasitic on those other powers. So that's page 18 of the authorities bundle, section 9, experimental traffic orders. 1. The traffic authority for a road may, for the purpose of carrying out an experimental scheme of traffic control, make an order under this section, referred to as an ETO or experimental traffic order, making such provision as be made ... 1B under section 6. So anything you can do under section 6 in Greater London you can do by way of the section 9 order as well. Yeah. The critical qualifying features of orders under this section are, first of all, and this is, we don't have it in the bundle, it's not controversial, it's dealt with by the judge, but the UK waste management case, it has to be for the purposes of a general experiment, so you can't use this section to kind of get round the restrictions that would otherwise be imposed. There was a ground relating to compliance with that aspect below, it's not pursued in this court. And secondly, it's like a traffic horn, may need a traffic regulation order outside the courtroom. Secondly, subsections 3 and 4 impose quite important restrictions. So, subsection 3, an experimental traffic order shall not continue in force for longer than 18 months. And that's a hard limit, because see subsection 4, although under subsection 4 you can extend the period of an order, that's still only where it's the original ETO is made for a period of less than 18 months. So the 18-month limit is a hard limit. At the end of 18 months, that's an end of the matter.
Can there be a further experimental order made?
Well, the statute doesn't spell that out. I would have thought that, I mean, query whether there's an absolute prohibition on doing that. Maybe, maybe not. It doesn't arise on the facts of this case, certainly at the moment. But I would say that it's certainly implicit in the statutory scheme that, for most purposes, you get your 18 months and then you ought to have completed your experiment. Now, whether there could be an exceptional case where it could be said to be rational, I don't think we need to decide.
Well, it's not an issue here anyway.
It's not an issue, so yeah. But for most purposes, to answer the question, I would say, for most, if not all purposes, it must be implicit in the 18-month limit. You can't just start again and keep starting again and keep starting again forever, and thereby permanently evade the other requirements of the permanent order. The other thing to just, again, nothing particularly turns on it, but it's useful just to get it under our belts, is some of the procedure then is set out in the 1996 regulations, which we have at tab 3.
Oh, yes.
And in relation to that, if we just pick up, and the purpose of doing this is really just to pick out certain features of experimental orders and how the process for making them differs. So if we can start at Regulation 6, which is on page 34 of this bundle.
Yes.
This is what I'll call, for want of a better phrase, the statutory consultation requirement, or statutory bodies consultation requirement. It's headed consultation. So this requires that certain bodies are consulted before an order is made, any form of traffic regulation order, that is. And this, by the way, applies not only to permanent orders, but also, as we'll see in a minute, continues to apply to experimental orders. The types of bodies we don't need to detail, but you can get a flavour of it just by looking in the third column of the table. It's various statutory bodies who might be expected to have an interest in such matters. But perhaps of note, in item 7 in the first column, for all cases, there's a requirement, and then the third column now, requirement to consult the Freight Transport Association, Road Haulage Association, and then C, such other organisations, if any, representing persons likely to be affected. So there's a discretion there, plainly it's not a requirement to consult anyone in particular. But it provides for consultation of, for example, representative bodies, and that would certainly potentially encompass, for example, representatives of disabled groups. Yeah. So that's Regulation 6. Then 7 and 8, again, we don't need the detail because they're not in play, but we just need to note their existence. So 7 is about publication of proposals. It's proposals, not the order. So in the ordinary case, what you have to do as the authority is publish your proposals for a traffic regulation order, setting out what you're going to do before you make the order, before you make a decision to make the order. And then that gives rise in Regulation 8 to a right to make objections by any member of the public. So collectively, I think of these as a sort of public consultation requirement, although that's not how they're described in the regulations. I think that's a legitimate paraphrase. And that can lead to, needn't, but can lead Regulation 9 to the holding of a public inquiry. In certain cases, there's a requirement to do so. In other cases, there's always a discretion to do so in the face of objections. So that's, if you like, the ordinary process in relation to consultation with statutory and bodies and the public. The scheme is modified for experimental orders. If we go on to page 50 of the bundle, that's in the pagination provided by those who prepared the bundle. There's a Regulation 22 is experimental orders. The one we want is the first because that's England. There's then the Welsh provision lower down, so you can put a line through that. And that materially provides the provisions of Regulations 7 and 8 shall not apply to an experimental order. So if you're carrying out an experimental order, you can short-circuit the process. You don't have to go through that process of what I've described as public consultation. You do have to consult with statutory bodies, of course.
So it's Regulation 7 and 8.
Yes. So that's publication of proposals and then the objections that I showed you a moment ago.
Yeah.
And then finally, to complete the picture, so that's why, obviously, in some ways, it may be more attractive or more expedient from an authority's perspective to suggesting that necessarily means improper, but to go down the experimental order route. And then Regulation 23 is about orders giving permanent effect to experimental orders. And then you'll see that this regulation applies where the sole effect of an order, a permanent order, which is not an order made under Section 9, so it's not itself an experimental order, is to reproduce and continue in force indefinitely the provisions of an experimental order. So in other words, I'd say it's about converting. Again, regulations 6, 7 and 8 are then disapplied in relation to such an order, but certain alternative requirements are imposed, which can include requirements of information gathering and consultation. We don't need the detail of that. You're not concerned with the detail of that. This case is not about that process.
Right, so that doesn't apply.
It doesn't apply to anything you're looking at, but again, it's worth being. I think it's useful just to be aware of it, not least because of the point made by Mr. Mould earlier this morning. Because my understanding, subject to correction, is that what the council has decided to do is to use this process of making the existing experimental orders permanent.
So it was a Regulation 23 process.
Yes. And that may matter for the future, and I'm not going to develop this any further because I'll wait to see what, if anything, Mr. Mould says about it, but that may matter because it means effectively that the lawfulness of any conversion order, we would say, must necessarily depend upon the lawfulness of the pre-existing experiment.
Well, yes. That,
I mean, I can see that's not a straightforward thing, but I just want to flag.
I mean, presumably you would give that answer to the question, which I haven't yet asked, and don't ask.
No.
Are these proceedings academic?
Correct. Yeah, and that's why I flag it, and I don't develop it further, but that's the point.
But I mean, nobody's suggesting at the moment, as far as I know, that the proceedings are now academic.
At the moment, no one's suggesting it. There's, if I can put it like this, there's a hint of a possibility that it might be raised, perhaps, and therefore I raise it in that limited way and take it no further from that. But I certainly don't need to say more about it. But in any event, I show you.
As far as I'm concerned, we don't need to get into that.
No, we don't. We definitely don't. We definitely don't.
Suggestion of a hint, I ought just to reassure on that, because otherwise we have that cloud hanging over us. For my part, there's no hint of a suggestion that these proceedings are academic as things stand.
Right.
Not least because there's at least one set of orders, as you know, the Streatham Hill orders, that remain in full force as regulation, as Section 9 orders. But even in relation to those sets of orders that are the subject of a decision that I mentioned earlier, that they should be made permanent. The question goes only to relief, if it goes anywhere. There may be a debate about whether, in the event that the appeal were allowed on the ground that is put forward, the court should consider limiting itself to declaratory relief only, or whether it should make a more intrusive decision, for example, a quashing order in relation to those orders. But that debate doesn't render the proceedings academic. It goes only to the question of what relief the court ought to give in the event that it upholds the substance of the appeal.
In order to answer that question, it might be necessary to know something about the different procedures which apply when you make a permanent order without there being an experimental order, and when you do what the council has done or has purported to do, which is to make an experimental order permanent. If those procedures are materially different, and if the council has taken, as it were, a route which would not be open to it if it were making a permanent order without an experimental order, then that might be important to know in order to answer your relief question.
My Lord, yes, and as I understood Mr. Gewley's brief analysis of the regulations that he's just been showing, he's drawing attention to the differences in terms of statutory procedure that potentially bear on that point.
Yes.
I would suggest, subject to my Lord and my Lady, that we don't venture into that at the moment. It may be that submissions become appropriate, or it may not, on that point. But I don't think, for my part, that it's necessary to go there for the moment.
I'm entirely happy with that, yes.
Okay.
Well, Lord, if I'm helpful to say so, I'm completely happy with that as well. I didn't want to take the point any further than
No, fine. No, I mean, this arose from a question or an observation that I made, but I think that is fine. We don't need to get into the territory that my Lord has described.
No.
Though that might be
these issues could be relevant to it in the future.
Relevant territory, but we don't need to go there now.
Correct. I'm grateful. That's all I wanted then to show you about the statutory scheme.
Yeah, thank you.
And that brings me to the next topic in my submissions, which is the facts. Now,
Yes.
in relation to the facts, the judge provides a very comprehensive and, for my part, correct account of the chronology, as it were, of decision making. I'll come to that in a moment.
Yeah.
There is just another aspect of the facts that I want to touch upon before we get to the judgment, though.
Right.
He doesn't particularly mention it. I don't think that means he doesn't accept the basic point that I seek to make by reference to it. And that is in relation simply to the impact of a traffic order, or the potential impact, perhaps I should say, of a traffic order of this kind upon my client and upon disabled persons generally. Now, I'm not for a moment inviting the court to make findings on that issue.
No.
It's not appropriate.
No.
All that I seek to show you, by reference to some brief references I'll come to in just a moment, is that there are, on any view, potential impacts for disabled people.
Yes.
By reason of order of this kind. And our complaint, the complaint at the heart of this claim, ultimately, obviously made through Section 149 of the Equality Act, is that those impacts, those considerations were not addressed at all by the council in making the order. That's our case. So to make that good, I just want to show you two documents, if I may, briefly. Right. The first is my client's witness statement, which is the first document, and therefore tab 1 of the supplementary bundle.
Yes.
And I should add, before the judge, there were some further witness statements from, as it were, supporters to similar effect. We haven't included them for you, I don't think. As I've said, it's only to illustrate the point, not to invite you to make findings on it. But you should know that it wasn't, as it were, only my client by any means who was concerned about this. There was very widespread concern. So, my lady, my lords, if we go then briefly to the statement, my client sets out paragraph 3 on page 1 of, there's double numbering in the first few pages. It does disappear quite soon, but we want the left-hand one. So page 4 of the bundle behind tab 1.
Yeah, I've got it.
She sets out in paragraphs 3 and 4 her condition. Obviously a very serious condition. Condition, chronic pulmonary sarcoidosis, I hope I pronounced that correctly. And some of the impact of the condition itself upon her, due to that, of course. As she says in paragraph 4, that prior to this she was very physically active, and she tended to be tend to make things on foot. Then in paragraph 6 in particular, under the heading "How I Get Around," she explains why, since her condition has developed, she's bought a car, and the use of a car has become particularly important for her in terms of ensuring her mobility. Yes. It's obviously important then in considering the effect of an orders of the kind we're concerned with on her. And then under the heading "The Effect of LTNs of the LTNs on My Life," from paragraph 8 onwards, she sets out a series of considerations. I'm not going to read them all out. No doubt the court can read them insofar as it needs. I don't think any of this is disputed. It's not disputed that there are at least potentially significant effects on her. Yeah. The first heading in particular, longer journey times, has, since the decisions in this case were made, been recognised by the council as an issue for disabled people generally. The others may be more controversial, but there's no analysis to say they're not true in a sense. So in a sense, I say, well, the important point for my purposes is these are matters which should have been thought about. So under the longer journey times, she says, my car journey times have doubled or even tripled since the LTNs were introduced, and I only go out in the car when I have to, and my ability to get out in the community is severely curtailed. Obviously, that's actually a very serious matter for quality of life of any person. She explains, and I don't read it all out, but she explains a number of points, and just to pick up, paragraph 13, in a sense explains why, in particular, the impact of increased journey times is important for her. It's not just that increased journey times are inconvenient, as they would be to anyone. They're positively uncomfortable or even agonising because of her condition. That's paragraph 13. And likewise, paragraph 14. it's probably worth just making the point. In paragraph 14, third sentence, she's talking about a particular journey, but it's illustrative of the wider problem she suffers. My journey home took 37 minutes instead of 11 minutes, which it took previously, and this is the point I just want to draw attention, both because I couldn't use the roads which were closed, and because the roads which were still open were far, far busier than usual. So certainly her experience is, maybe controversial, but there's no consideration of it, is that there's these impacts. It's not just that she can't drive through an LTN, let alone a particular LTN. Mr. Mould has told us this morning that she may be given in the future a dispensation in relation to her local LTN, yes, not others. But actually driving through any of them may be important to her. But also because the knock-on consequences of that on traffic. Yeah. So that's, I mean, as I say, you get the thrust of the complaint in the rest of, in all of those paragraphs. That then, under the heading effect on social interaction, is a further knock-on consequence. I think it's a knock-on consequences of the longer journey times, but that has effect on her ability to have social interaction. Again, obviously a pretty fundamental feature of anyone's quality of life or private life. And she talks about various other impacts, noise and air pollution, medication, carers and so forth. I won't read them out, you see the So I say simply in relation to that, not that the court should make any findings about it, but that it obviously shows that there are, in play at any rate, potentially significant aspects on disabled persons such as my client, in particular though not only those who are reliant on cars for transport, and that those are matters which, effectively my cases, which ought to have been considered in greater detail than they were. I'll come on to that. The other document, again to make that good, but in a more general way, which I wanted to show you then, and again it's quoted in the skeleton, you may well have seen it, or seen the thrust of what it says, is the report produced on behalf of the Department for Transport. This is at tab 6 of the supplementary bundle. You can see from page 73, don't turn it up for this alone, that it was produced in 2017, so it's extant, well before the decisions we're dealing with. Page 75, there's a foreword, tells you something about its status.
Sorry, I must be in the wrong place.
I'm so sorry. So, page 70, supplementary bundle, tab 6.
Yes.
Page 75 in the bottom right.
Yes.
You have that. There's a heading at the top of the page, forward.
Yeah. It's page 48, I think you want.
Oh dear.
Yeah, it's not that page.
Ah, that may mean that I've got an earlier version.
The forward's on page 48, as my lord says.
I'm grateful. Well, it may mean some of my references are out in that case because I've been working. I'm very sorry about that.
All right. Well, don't worry. We'll make sure that we get to the right tab.
Yeah, sure. Is it? Can I ask? Is it behind tab 6?
It is.
Yeah.
Okay. Well, then that may mean that we can navigate further.
Is it internal page 4?
It is internal page 4. Yes.
Right. Okay. You can use internal page.
I'm great. Yes, that will be very helpful, and I can probably do that for quite a lot of the other documents.
Yeah.
Okay, so the only point to make about this is it tells us something about the status of the document. So commissioned by the DFT doesn't, as it were, warrant the findings, but it's still produced on their behalf, and we'll see the purpose for which it's produced in just a moment. So if the court then turns the page, so internal 5, there's an executive summary. I'm not going to go beyond the executive summary today, as I did not in my skeleton. We don't need to delve into the detail of the findings at all. But we can see, first of all, under the heading aims of report, something about the purpose, and you can get the purpose sufficiently, I think, from paragraph 1.1. It's about addressing gaps in the evidence base in relation to travel behaviour of disabled persons. That's developed more fully in paragraph 1.2, but I don't need to read it. I've set out in my skeleton, and I briefly draw attention to then the cross-cutting themes. I take it these are the key conclusions. It said key themes, but I think that means the key conclusions of the report. Yeah. And there are 3, and they're worth just noting. So disability is a key characteristic for explaining travel behaviour, how this changes over time, and the factors, etc., that affect it. It is not simply the case that people with disabilities exhibit different travel behaviours because of their distinctive socio-demographic profile. In other words, disability is not acting as a marker for something else like income or something. In and of itself, it's an important factor. Secondly, importantly, people with disabilities should not be viewed as a homogenous group in regard to travel. That's, in my respectful submission, a very important point in this case. Bear in mind the point about, well, I'll come to it, but one of the things that the council placed a lot of weight on is how great this would be for disabled cyclists, which might be right. But of course that doesn't address the needs of all disabled persons.
No.
So disabled people are going to have a range of different needs.
Well, this claimant cannot use a bicycle.
Yeah, she definitely can't.
She
You
can
can
only
see that very clearly from what she says about the needs.
she can only use a car
Yeah.
for travel.
So and again, she's as this report makes clear, she's representative in that regard. That's why I know she's no either one of. Obviously, there may well be, I don't doubt for a moment, there may well be some disabled people who are able to cycle, who are currently discouraged from cycling because of high levels of traffic or whatever, and for whom a low traffic neighbourhood might be a jolly good thing. But you need to, if you're going to comply with the equality duty, you need to consider all the other people too. That's a simple point.
Understood.
Yeah. And then bullet 3, there are substantial differences in behaviour and experience of people with disabilities in relation to different modes of transport. It's a similar version of the same point. And then just to pick up, it's really just to develop those points very slightly, I hope, without labouring them. If we go to the next page, 1.3, people with disabilities travel less and undertake travel for different purposes compared to people without disabilities. Again, emphasising that the differences that disability makes. However, the population of people with disabilities is far from homogeneous. We've just seen that point. And I just draw attention to the third bullet point of this paragraph. As well as there being differences between the travel behaviour of people with and without disabilities, the behaviour of people with specific types of disabilities is often markedly different to each other, while people with disabilities are less likely to ever walk or cycle. So that makes good the point I just made a moment ago about my client being representative. To walk or cycle or ever use public transport compared with those without disabilities, those who experience difficulties with personal care or balance are particularly likely to never undertake these activities. And then there's some statistics, all to much the same effect. And then I think I've just very briefly, I've emphasised in my skeleton, I think, the first bullet point of 1.4 and the last bullet point of 1.4 over the page 78. That's set out in the skeleton. It may not be particularly helpful to read it out, but it's all effectively it's all to the same effect, really.
Sorry, the last bullet in 1.
Last bullet of 1.4. So just the bullet immediately for 1.5.
Yeah.
On page 7. On internal page 7.
Yes.
And then obviously the report develops those matters in much greater detail. I'm not, for a moment, don't suggest that it's necessary for us to delve into that. But the simple point I make against that background, the witness statement on the one hand, the individual case and the report on the other, is that disability is obviously an very important factor in relation to travel patterns, travel modes of transport that are used, and very important, in my submission, in relation to the quality of life impacts that changes of that kind may have. And that's important because, as Mr. Mould is at pains to emphasise, what is due regard, and I'll come to it in the cases, but it's not controversial, it's true. What is due regard under the under section 149 does depend on the context. He's right about that. It does depend on the context. The context here, though, is of a decision which plainly has the potential, and I don't need to put it any higher than that because there aren't any findings in the decision making, which plainly has a very significant potential effect on disabled people specifically, and perhaps I should have said a very significant differential as compared with other people. It's a simple enough point, I hope, but there it is. So that's what I want to say about that. Then we need to say something.
Strictly, I suppose, a very significant effect on people with certain kinds of disabilities.
Well, yeah, I mean, as I've made clear, and as the report made clear, how it affects you will vary, and it may be that I don't deny that it may even be that there are some disabled groups for whom a low traffic neighbourhood will be a good thing, or people with certain characteristics terms of disability coupled with certain habits of life. So, for example, if you're an elderly person who can still walk and doesn't tend to venture beyond your local neighbourhood, that's something which reduces traffic in that immediate neighbourhood may be a jolly good thing. If you're a person who is able to walk but needs to go further afield and there's more traffic, it all varies. But in other words,
it'll vary from
to
person,
think about. Yeah.
It'll vary from person to person.
Correct.
And it'll vary from journey to journey.
It probably will. Yeah. But yes, absolutely. But the important point is there's something significant to think about and which needed to be addressed. That's the only point I made. So that's what I want to say about that, and then I was going to come to the chronology and the judgment. Now, as I say, the judgment is, the judgment is very comprehensive on the facts, and we can, I think, use it. Therefore, it may well be, as it is the case, that the court's read the judgment carefully. Yeah. No, I shan't wholly assume it unless you tell me otherwise.
No, well, I mean, you can assume. I should have said at the outset that you can assume familiarity on the part of the court with the materials, including, of course, the judgment of the judge and the court below.
I'm very grateful. Well, with that in mind, what I propose to do is, first of all, to note that the judge sets out the facts in terms of the chronology of decision-making between paragraphs 30 and,
30 and 100, I think.
30 and 100, I'm grateful, thank you. That, if the court's read it, then we don't need to get I don't need to trace through every document or every point of detail. What I would like to do, and it will be mostly by way of emphasis because there may be things...
Yeah, you can highlight particular
points and go, for those purposes, go to some of the documents. So with that in mind, I start in the same place as the judge does. Forgive me, I've got a bit of a frog in my throat. I start in the same place as the judge does with paragraph 30, 18th of November 2019. This is when the council approved, by way of a cabinet decision, the transport strategy and transport strategy implementation plan, which we have in the bundle for me at, I think it's tab 9. Yeah, tab 9. So what we have in the bundle is, first of all, the report to cabinet. Secondly, I'll just highlight a few documents, a few passages in a moment, just so we see what we've got. Secondly, the transport strategy. Thirdly, the TSIP, the implementation plan. And fourthly, an equality impact assessment, which accompanied all of that.
Yeah.
So all we need to say, and I'll say something about each. In terms of the cabinet report, then, the recommendation you can see was page. Now my page numbering is going to go wrong again, but it's just behind tab 9, I hope.
Yes. So you want to bring our attention to the cabinet.
So what I want to draw your attention to is the cabinet report, effectively the first page, other than the exhibit page, behind tab 9.
Yes, it happens to be page 157.
157. Whether I can rapidly do the maths to convert that in each case, I don't know. But
well, it's also got some handwritten numbering.
It has got some handwritten numbering, hasn't it? So page 1 of the handwritten.
Page 1 is page 157.
And the only point to make about that is the recommendation is to approve the TS and the TSIP. See the bottom of the page on the first recommendation.
Yeah.
But I think I should just, it's useful to note, I think, first of all, it's useful to note that this document does deal with equalities impact assessment. So that handwritten internal numbering, it's page 5, if that's consistent.
Page 5, yes.
Section 7. This is we'll see this is a pretty familiar format for these reports. And there's a section there on equalities impact assessment.
Yeah.
Now, obviously, I'm not concerned. I'm not making any challenge to this decision, nor could I, for all sorts of reasons. And I have no complaint about it, but it's important to see the limits of what was looked at. So with that in mind, without reading down, if you just note, I think it's really 7.3, you get a sense of what was looked at, as in particular, because the transport strategy did include within it proposals for low traffic neighbourhoods. But the things that are emphasised certainly at this stage in paragraph 7.3 are other matters, not low traffic neighbourhoods. So in particular, and most importantly, a lot of the paragraph is taken up with promoting step-free access to public transport, and that's obviously a good thing for disabled people. No one will dispute that, and that's the context in which this is being regarded as positive, and in that sense, it no doubt was. Other things that are picked up on about 6 lines from the bottom: bus ridership and inclusive cycling initiatives. I don't know if inclusive cycling initiative could be said to include low traffic neighbourhoods, but it certainly doesn't do so in any very specific way.
Well, the point I think you're making, perhaps above all, is that this does not condescend to grappling with the equality implications
Of LTNs.
Of LTNs.
That's the point. That's the only point. So we should then note briefly, and that is the only point I wanted to make about it. The transport strategy then starts. I hope this still works. Internal 7.
Yeah.
And it's a document. I'm going to confess, I'm not 100% sure where the transport strategy ends and the implementation plan begins. It looks like it might be internal 16, but there are some things that cause me to doubt that, but we need to develop it. Anyway, in the what I understand to be the transport strategy itself, I don't think there's any specific reference to low traffic neighbourhoods.
No.
My caution about that is on internal 15, there's a part of a table which does refer to LTNs. I think actually, and this is where I think the page numbering may have got a bit nubbled, that might be in the TSIP rather than the TS, but anyway, nothing turns on it. To that extent, they're mentioned.
And we don't have internal page 15 in the event.
So that
We
was
have
taken away.
internal
Well,
page.
that's probably why you're
a victim of the cull.
I think there was an attempt. Well, there was a successful attempt to reduce the size of the bundle to comply with court strictures, and I'm afraid I just haven't.
Strangely, as some will have noticed, there are 3 page numbers on that page, page 16.
Yes, page 16. Yes, the TSIP.
Now that's the.
Which you do have.
That is the TSIP.
Well, I think so. But the reason I hesitate about what's in what is if you go on a few. Well, again, I don't know if you've got this, but if you go on a few pages, there's to my internal 19. Do you have that?
Yes, we do have that.
That
is page 4 of something.
Yes. Oh, I see. It might not be the same.
Well, what I want.
Nothing turns on it.
Maybe nothing turns.
Nothing turns on it.
Is the submission here, just to be absolutely clear, is the submission here that neither the transport strategy nor the transport strategy implementation plan made specific reference or meaningful reference to LTNs?
No, the submission is that the transport strategy doesn't.
Doesn't, yes.
The transport strategy implementation plan, I'm going to show you, goes a little bit further.
Right.
So let me show you what it does do, and then I'll make
Fine.
try and encapsulate where that leaves us. It
Well,
would be overstating to say it makes no reference.
All right. Well, it seems pretty clear, unless we're corrected by Mr. Mould, that when we get to page 16, manuscript, 163, bundle pagination, page 1, internal pagination.
Yes.
We're into.
Yes,
we seem to
that's
be into
correct.
the implementation plan.
That must be right.
That seems right. Yeah.
That must be right. Yeah.
Okay. Well, I'm going to, if you don't mind, I'm just going to write a tab TSIP.
Yes. I've done the same.
And put that on.
Yeah. I think that's where it starts, but the reasons I'll bore you with, I had some slight doubts about whether some of the later pages included. Now, within the TSIP, there are some references to low traffic neighbourhoods, so I need to acknowledge that.
Yeah.
But actually, they're quite striking. So if we can go, and I hope you have this page 21, internal handwritten.
Yes. Which is 168 bundle.
168, I'm grateful. I don't promise to remember it, but I'm grateful.
Well, don't worry.
So there's a heading you'll see, working with the community to deliver change.
Yeah.
There's a paragraph, the transport strategy has been agreed, etc. But then it's the next paragraph I'm interested in. Engagement with the community on the development of the transport strategy is a starting point. The projects and programmes we will now deliver as a result have community engagement at their heart. Key programmes such as Healthy Routes and Low Traffic Neighbourhoods can only proceed with the support of local people, and we set out our approach to engagement in the relevant appendices of the document. I'll come to the appendices, the relevant appendix rather, in just a moment. But so the submission here is not quite that it doesn't mention them at all, but it doesn't condescend to any analysis of them. On the contrary, of their equality impacts. On the contrary, it recognises that as being a matter for future work, or it recognises the general implications of the scheme.
You're looking at the penultimate paragraph on page 21.
I am.
Yeah. Yeah.
We've then got Appendix A. I don't actually, you may not have it. I hope you've got Appendix B, which starts at internal 31.
Yeah.
Do? Yes.
So that is TSIP Appendix B, and you'll see the heading is Low Traffic Neighbourhood Plan. So obviously this is getting into a bit more detail about them. But the simple point, again, well, let me show you the passages. So if we go over the page, there's so do you have internal? Oh dear, my internal number is now deserting me altogether. There's a non-handwritten number 22.
Right.
And at the bottom of the page, there's a reference to Vauxhall gyratory. You have that?
Yes, and that is page 171. And
151, grateful. Now that's what becomes the oval triangle, effectively.
oh, yes.
Give or take. I mean, I'm not saying it's got the exact same parameters, but it's broadly. You'll see at the top of the next page,
It is a triangular area.
It is. It is, yes.
And it excludes the oval cricket ground.
Yes, yes.
On its northeastern
It
side.
does. So there's plainly is some anticipation of what later becomes oval triangle at this stage. There's some anticipation, you can see on the next page, of what becomes Streatham Hill.
Yeah. Well, Streatham Hill affected area is that trapezoid area.
Yes, give or take, I don't know. There's no question they were looking at the general area.
Yeah.
I don't think there's anything in relation to Railton and St Matthews here. But in any event, really the critical point, if we go on to the end of this appendix, internal 34, I'm going to venture that it might be page 175. Maybe done my maths wrong.
173. So do you mean page 34?
I mean page 34. I do mean page 34. There's a heading timescales.
Yeah, that's on page 173.
Fine, I've guessed wrong.
Right, that's fine. Well, we're managing.
We're managing. And under timescales, it's really just the same point. So for the first tranche of LTNs, some initial assessment work has already begun, and this work will now accelerate. It is difficult to specify an exact timescale for projects such as these, given the need to fully understand the impact of the interventions and the views of the community in each area to make sure we get it right. That's the bit I rely on, and then the rest continues. So again, it's the same point. Yes, there's a recognition. There's no doubt that at a high level, the TS and the TSIP are contemplating low traffic neighbourhoods. That's perfectly clear. But they're absolutely not condescending, to adopt my Lord's word, to any kind of detailed analysis of whether they're a good thing or a good thing in a particular case or anything of that nature. On the contrary, they recognise that the impacts still have to be assessed. It doesn't do the job or part of the job that we say has to be undertaken under Section 149.
Don't we see some of that, at any rate, in a general way, a high-level way, at internal pages 38 and 39, which talks expressly about the position of disabled people as well as other affected characters?
So, my Lord, that's in the equality impact assessment. My answer
is that part of this document, or is
no,
it
it's the next document. It's the next document. So the next document is the equality. So remember, I said there were 4 documents. There's the cabinet report. There's a TS. There's a TSIP, and there's the EQIA, the equality impact assessment, which accompanies the package.
Right. It's not terribly easy to tell.
No, I know.
I'm
sorry.
And they're all, and this is the 4th of October 2019, the EQIA.
Yes.
Well, it is. I'm
Yes,
reading
yes,
the
yes,
date
yes.
off page,
No, it is. I
page
agree.
36 in
Yes, it
manuscript.
is. So it's obviously been prepared slightly in advance of the cabinet
Yeah,
report.
but it's part of this set.
It's part of the package, and there's no question that it accompanied the cabinet report and the other documents. So, but as to the analysis, my lord, I'm not sure about 38 and 39. In the EQIA, remember, I'm ultimately focusing on disability.
Yeah.
I don't go so far as to say there was no analysis at any level of any of the impacts, equality or otherwise, What I say is there wasn't anything like the kind of detailed or proper analysis under equality. Now, in relation to disability, in the EQI at this stage, that's on internal 41.
Yeah. Manuscript 41. Yeah.
I'm so sorry, manuscript 41.
Yeah, which is 180 in the bundle.
I'm grateful. So you can see disability, the conclusion is positive, and there's a paragraph which follows. Now, since I'm relying on it to show a negative, I won't read it out, but the simple submission is there's nothing there about LTNs in particular. Again, it's about things like step-free access and so on.
Well, what I was looking at was the third from the bottom bullet point on manuscript page 39.
I'm grateful. Can I just, sorry, let me just catch up with my lord. We will prioritise this.
Prioritise car parking for disabled people, recognising the critical role cars will continue to play to enable mobility for people for whom walking, cycling or public transport are not available options. Now that essentially is your client and others in her position.
Well, sure,
It's quite right to say that it doesn't go on to say that low traffic neighbourhoods will, what consequences that may have, but it does at least show that the critical nature of motor vehicle transport was
certainly
a factor.
Sure, it's not my submission that they were wholly unaware of the value of car transport to disabled persons. That's not my submission. When we get to, but there's nothing here which relates to the implications of a low traffic neighbourhood and the impact that can have on the mobility of disabled people who relies on cars. This is about something else. It's about a very well recognised need for disabled parking. And that's not addressing the problem. It's addressing a different problem. Right? Sorry. I mean, I hope that doesn't. I mean, I wholly accept that. That's there is some recognition of the importance of cars to disabled person. That must be right, and it's implicit in the recognition of the need for disabled parking.
I'm sorry to interrupt you.
Yes.
Forgive me. How is it qualified or narrowed down then, in the way that you may have suggested? You're saying.
I'm not sure I would say it is qualified or narrowed down. It's recognising something specific, which is the value of disabled parking.
Yes, but how does it not then relate to low traffic neighbourhoods?
Forgive me, putting it this way, I don't see how it. I mean, it's for me to make submissions, but I don't. In a sense, I don't see how it does. I mean,
no.
Implicit. So the specific point that's made.
Yeah.
Is that car parking for disabled people is to be prioritised. That's the specific point.
So it's
so far so good.
It's about prioritising car parking.
Yeah. Implicitly underlying that, I think this is the point my Lord Justice Mayles makes to me, is a recognition that that's because there must be at some level a recognition that that's because car transport may be important to disabled people. So that's implicit, I think.
Yes. Well, implicit here in the final bullet point on the previous page, older disabled people use public transport less than other groups.
Yes, I mean to that extent. But it's not engaging with a much more specific point that arises when you designate a whole area of the borough as
but you said that you have to read the whole thing, and and the context is prioritising car parking.
Absolutely, yeah. It's not doing. I don't understand Mr. Moles otherwise. It's not doing the job 2 years in advance.
No.
that needed to be done when you.
No, I mean perhaps I don't know, but perhaps the highest it can be put would be to say that this does indicate or may indicate that the authors of this assessment were conscious of that particular need.
They were conscious of that particular. Yes, that's probably right.
Well, it's identified as a priority action. I mean, there's a lot of reference in the bullet points above that to the general general conclusions about the way in which different people with people with different protected characteristics use transport. So there are several references to, for example, older and disabled people use public transport less. Overcrowding cited as mole groups as a barrier. The references to disabled people in that bullet point, and then women, old and disabled, are less likely to walk or cycle, and so on. So there are some general themes about people with protected characteristics, including those with disabilities, which are
Yeah,
identified.
I would extend that.
Yeah.
But I say that doesn't. I mean, the critical purpose of all this is to show you that certainly I would submit there's no sense in which it can be said that this undertakes anything approaching the kind of detailed or analysis, or even frankly high level analysis of the question of what low traffic neighbourhoods may mean for disabled people who are, for example, reliant on a motor car. Still less of what any particular low traffic neighbourhood in any particular neighbourhood may mean, or for example, whether some concessions should be made to allow them to drive. All of those questions, which are the sorts of questions which need to be analysed when you're thinking about the impact. There's no way that that's addressed here. And I just come back to the overall context, to come back to that I've showed you in two passages, for example, under the heading timescales on page 34, it's already shown you. It's expressly recognised that when you come to LTNs, further work is required. That must necessarily include qualities.
And sorry, that is on page.
That was on internal 34, and I'm so sorry. I think my lord said it was on page 173 of your bundle. Under timescales, is that
Yes,
right?
you've mentioned that already. Yes.
So that's the transport strategy and everything that goes with it back in 2019.
Yes.
The next thing we should pick up, I think, in the chronology is in relation to, forgive me, is 9th of May 2020. The judge deals with it at 30 pages, paragraphs 37 and 38. So this is the publication of further DFT guidance. And in particular, so he quotes in paragraph 37 of the judgment, he quotes, I think we don't need to turn the document itself up,
No.
but in paragraph 37 of the judgment, he quotes, he quotes from the guidance which says, the second paragraph, quote, government expects local authorities to make significant changes and so forth. And then paragraph 38 over the page in the bundle. I'm hoping that my pagination for the core bundle is the same as the course. Do you have page 60 for this?
Yes.
That's helpful and relieving to know. So paragraph 38, under the heading reallocating road safety measures, the document stated measures should be taken as swiftly as possible and in any event within weeks, given the urgent need to change travel habits. Now the judge saw a lot of significance in that, and I think Mr. Mould sees a lot of significance in that. My simple submission about it is that guidance of this kind can't significantly change or alter the basic obligations imposed under section 149, but again we'll come to that and we'll see what the judge says about it. At any rate, that's published on the 9th of May. Next bit of the chronology, I think we do just need to turn up the documents. So paragraph 39 of the judgment, the judge says that the...
Sorry to interrupt, Mr. Beard. Can I just ask a
My
question
lady, yes.
about that? As I read the judgment, you didn't submit that the local authority in this case erred in having regard to the guidance in the way that they did.
I didn't submit that they erred in having regard to it, no, and I don't submit that.
Right.
What I say is that having regard to the guidance doesn't alter the need to comply with section 149, which requires... It may, I suppose, colour it. It may, I'm not sure I accept that actually, but at most in a very limited way. The statutory duty in section 149 stands as a statutory primary Parliament is required. Does that deal with my lady's question for now?
Yeah, so you're in a slightly equivocal way accepting that the complying with the guidance may be relevant to section 149.
I accept, as Mr. Mould emphasises to the court, and as I accept, what is due regard is going to be highly contextual. That's right. The authorities are clear about that.
Yeah.
So one feature of the context here is the government was encouraging authorities to act quickly. That is a feature, therefore, of the context. To that extent, I accept its relevance. I don't accept don't accept that it is a significant feature of the context which is capable of significantly, at any rate, altering the nature of the duty imposed by section 149, or how that's to be applied, if that's another way of putting the point. And there's also a feature of that which, on the facts, which is what, and we'll see this in a minute, but what, of course, the council did in at least two of the cases, Railton and Oval, was it, in order to meet the need for speed, if I can put it slightly colloquial way, it brought into force temporary orders even before it brought into force experimental orders.
Yeah.
Which further, in my submission, reduces any need for expedition of a kind which could begin to justify not doing a proper analysis. After all, they'd already secured temporary schemes to comply with the government. So that's getting ahead of myself to the submission I was going on to, but I make it now because the issue arises.
Yeah,
and of course, although they didn't do that for Streatham Hill, sorry if I just make a point, they didn't do it for Streatham Hill, but of course they could have done it, presumably.
And that was a response to the need for speed, as you put it.
Yes. So there wasn't, it's very difficult to see how the government guidance, in a context where the authority had been able to, and had in fact, in two of the cases, put in place these temporary orders to very similar, if not identical, effect. It's very difficult, presumably precisely to buy some time to do some harder thinking, as it were. Yeah. Very difficult to see how the government guide, and they'd done, in relation to Oval, they had done it within weeks. In relation to Railton, it's a bit longer, we'll see the chronology in a minute, but it was still done pretty quickly. Very difficult to see how the need for speed, under the guidance, if that's what its effect is.
Is this an argument you ran below?
No.
Because I don't remember seeing any trace of this.
No, I mean, I think it. No, I don't think I made that specific point. My lady, it's a fair question. One develops the way one thinks about the case. I mean, to some extent, the point about speed was a point, I think, which emerged during the course of the hearing. So, but I mean, it's only about context. It's not a new ground. It's just part of the overall context.
Is there a temporal limit to the duration of a temporary order?
I confess that I don't know off the top of my head.
Because you say they bought them some time, and,
yes.
and therefore, but that rather depends on whether there is.
Well, it does and it doesn't. I say frankly, I don't know the answer to my Lord's question at the moment. I can check it, or someone else might help me out. I don't know the answer to my Lord's question, but whether or not there is in a sense by the by, because if you've got yourself the ability to buy some time on any of your significant about things, they certainly lasted for a number of months, then in a sense you can be reasonably expected to use whatever time bound limited number of temporary schemes to do the relevant thinking. So I don't, and in a sense at a high level, I would say it shouldn't matter too much.
All right.
Sorry.
I think we'd reached the 15th of May.
Yes, the 15th of May, and I think we should, if I just turn that up. So that is behind, and again, the numbering won't be right, but the tabs fortunately will be. That is behind tab 10, I think.
Yeah. Yes.
Now this consists effectively of, in the way we had 4 documents in the 2019 decision, this consists effectively of 2 documents. So you've got the Cabinet Report, internal page 1, fortunately, that's again available. And then there's the COVID-19 transport programme, which is being approved. So all we need from the Cabinet member delegated decision, so we need on page internal 1, recommendation is to approve the Council's COVID-19 transport programme. The transport programme begins on internal 12, it's appendix 1 to the report. It undoubtedly identifies, you can see on page 12, intervention types
Yes, it's page 202 actually.
Yes, 202, I'm grateful. It had intervention types. You can see, first of all, there's footway widening, but then the next one, the bullet point at the very bottom of the page is low traffic neighbourhoods, and the text relating to that is over the page, accelerating and expanding the planned TSIP programme, and then there's more detail in Appendix C. But for my purposes, all I want to show you in here is what the legal effect of this was. And you can see that if we go to internal 15, there's a heading governance.
Yes.
And there's a description of various roles that would be played by various persons. And then importantly for our purposes, penultimate paragraph in this section, so roughly the middle of the page, the Strategic Director for Resident Services. You have that. Will be responsible for delegated decisions relating to project implementation. So one thing that this does is it delegates the power to make implementing decisions, i.e. effectively to decide to make specific orders, to that person, who is Mr. de Sommer, as we'll see shortly.
Yes.
So that's its effect. Now, then, if we can just then, with that in mind, go back to the Cabinet report for a moment to see how equalities are dealt with here. And if we just note, please, first of all, internal 5. This is just to show you, in a sense, the standard feature of the way these documents are produced. So on internal 5, the heading on the previous page is legal and democracy. And what this section 4 of the report does is it sets out a whole series of relevant legal duties that are in play and briefly summarises the nature of duties. And so at 4.8 and 4.8 all through to 4.11, it summarises the nature of the equality duty in a way that we'll see is also done in the later report.
Yeah.
But obviously that's not doing anything more than, as it were, directing in general terms what the duty is. It's not purporting to...
No. But is there any contention that was an inaccurate or inaccurate?
No, not at all. No.
I mean, as far as it goes, it's inaccurate and adequate.
Yeah, absolutely. Yeah. And then equalities, as it were, insofar as necessary for these purposes, discharged on page internal 8 under the heading inequalities impact assessment. So there wasn't at this stage a separate equalities impact assessment of the COVID-19 transport programme. That wasn't done at this stage. But there is some discussion of equalities. I'm not suggesting it's unlawful, but it's important to see how it envisages matters moving forward. So 7.1 and 7.2 set out various points of background, but 7.3 is what I particularly draw attention to. So it notes, correctly of course, the Transport Strategy and Implementation Plan 2019 was subject to a full EIA as accessible in the background. I think that means it is accessible to readers of this, probably. As accessible in the background documents listed in the report history section, etc. But then what I really want is the next sentence, beginning all traffic orders. All traffic orders required as part of the response will be subject to EIA. So it's quite important in my submission that in delegating this power to implement to the strategic relevance strategic director, Mr. de Sommer, it is explicitly envisaged that equalities impact assessments will be carried out before orders are implemented. Now, I don't go so far as to say that he's bound by that, but it's very important contextually because what it tells you is it's not anticipated by those delegating power that the relevant analysis has already been undertaken.
No, but it might be consistent, might it, with a continuing process?
Well, I mean, it is part of a continuing process. I don't doubt there's a continuing process from
you
2019 through 2020 and 2020.
You're not suggesting that it starts the clock or
no
takes a clean sheet
what is
of paper.
important is it is just as, I mean, when I showed you the 2019 what I was at pains to emphasise is that they're explicitly envisaging that further analysis is required. At that stage, actually, not just in relation to qualities, but generally.
Yeah.
Likewise, this is explicitly acknowledged.
Your point you're making is that this can only be read in one sense as saying that the task is not yet
Correct.
done.
That's suspicion. So that's the significance of that. First of all, that it's the source of the delegation on the one hand, and on the other hand, what it says about equality in both, I've just shown you.
Yeah.
What then follows, and we don't need to go to any documents for this, I think, is that a series, as I've foreshadowed in fact, a series of temporary orders are made. So, get my references, just taking this from the judgment.
Incidentally, the judge gives us the answer to my question. He says 18 months.
Sorry?
Incidentally, the judge says the limit for them is 18 months.
Well, there you go. Thank you. I'm grateful. So, no doubt I should have picked that up, but I think that rather makes my point, because they hadn't begun to use up the 18 months by the time that they moved to the experimental orders. So they had plenty of time. I'm grateful, my lord. So, my lords and my lady, then we go in the judgment, I think, to paragraph 47, where the judge simply notes that the TTO for the oval triangle was then made on the 22nd of May, pretty quick, complying with the need for speed, as it were. Then on the 4th of August, there's what's described as a draft EQIA in relation to specifically Railton. See paragraph 50. I think it would be sensible just to turn that up. The judge quotes one bit, but there's another bit, something else, or rather an absence that I want to show you. So it's tab 12 of the supplementary bundle. It appears undated, the document itself. So I'm not going to venture to suggest a page number because I'm sure I'll be wrong, but it's tab 12 of the supplementary bundle. But the date is the 4th of August. This is the document which the judge is referring to. The significance, by the way, of it being described as a draft EQIA, as I understand it, if we go on the first page of this, I'm afraid I just don't have any useful page numbering, so I'm invite the court's patience a little. You'll see proposal, title, C19, response, etc. Authors, so we're told who wrote it, who will sign off the assessment, Hannah Jameson, who will be involved in approving this decision, that's to say the decision in relation, as I understand it, the decision in relation to the EQIA, I think that's right, it might be the decision in relation to the temporary order, I don't know, Simon Phillips, but of course not Mr. Disonno, notably, and my understanding is this is described as a draft because these are future events, the sign-off by those people and the approval. So all that this has got to is the authors have written it, but not beyond that. And certainly it's not shown or seen by Mr. Disonno, there's no suggestion of that. He's the decision maker. Now the reason I just wanted to invite the court to turn the actual document up, just to make an additional point, is that, as the judge notes, and we'll come to it in just a moment, it deals with disability in a particular passage. So, but in fact, it omits to do so in a different way. So if I just, sorry, I haven't put that very clearly. Second page of the document, there's a heading, what do we know about the people who will be impacted by the change?
Yes. That's on page 238. Instead.
238, that's grateful. I'll do my best to catch it. So you can see then on what I think must be page 239,
yeah.
There's a beginning of an analysis by, as it were, protected characteristics. There's a heading age on that page, a heading socioeconomics and deprivation. Over the page there's a heading ethnicity, and then there's a heading transport, equity and health. It's quite striking, not the key point for me in the case, but it's quite striking, I suggest, that under this heading of what do we know about the people who will be impacted by the change, there's no attempt to identify the characteristics of disabled people in that. As they're on the logic of the document, there perhaps ought to be in the same way as is done for ethnicity and so forth. What it does do, I can freely accept, a few pages on, is that there's then a section which begins immediately after how will they be impacted. And if you then go on to page, what I think would be 243, but I maybe...
243.
I'm grateful. There's then impact by group.
Isn't the difference that the first section is dealing with the impact of COVID on people with different protected characteristics, and nothing specific is said about disability, whereas the impact of the proposed low traffic neighbourhood is then dealt with later, and disability
I think
is...
my lord may be right, so I may have made a bad point. Can I think about that in third time? But, my lord may have caught me out.
No, I wasn't intending to...
No, I know you weren't, but it's how it feels.
Understand the
It
structure
feels
of the
different from this end side of the bench, from this side of the courtroom.
I mean, we're just seeking to get to, you know, the real.
Absolutely,
The real
of course, and it's a perfectly legitimate point, and I wasn't meaning to suggest otherwise. So anyway, on page 2, so under the general heading, how will they be impacted by the change? And then on page 243, there's a section related to disability. So that to that extent, it does address disability.
Yes.
And the passage was set out by the judge. And you can see the general tenor of this is the benefits for disabled people of being able to walk and so forth, which of course potentially may be important, but they don't begin to capture all of the impacts. What
Just
is
read the penultimate sentence.
well, I was going to read a few more, actually,
Well,
third sentence onwards. For example, cycles can improve mobility and access for disabled people, many of whom do not have access to motor vehicles. For those that do have access to a car, in some cases, journey times may be increased for some trips. I think that's what my learned friend is drawing attention to. All areas will remain accessible, however, and so forth. So, you know, to that extent, albeit in a single sentence, it notes that point. That's absolutely right. What, of course, it doesn't do is identify the potential knock-on impacts for a disabled person as opposed to someone else of that. I.e. the point that I made earlier, that not only may your journey time be increased, but the fact of your disability may make that a much more significant factor for you than for other people. So anyway, that's that document. It's, as I say, it's a draft. There's no suggestion. There's no explanation of how it's taken into account in any of the decision-making, let alone in relation to ones under challenge in the claim. What then happens is, following on from that, 7th of August, TTO for Railton is then made.
So in a way, you're identifying as it were, a subset of disabled people. So you've got disabled people in general at a high level, then you've got disabled people who are limited to travelling by car, and then what you're identifying now is disabled people who are not only limited to travelling by car, but for whom prolonging journey times may have an additional impact because it causes extra pain.
Well, in a sense, that's right, but that reflects the general point I made earlier, my lord, which is that for disabled people, as we saw by reference, for example, to the DFT report, the impacts will be differential, and you need,
yes.
What I say you need to do, yeah, I mean, it maybe my simple answer is yes, but I mean, the point is, in other words, these are all things that which require to be analysed.
Yeah.
We say.
Okay.
That's the point.
Well, you'd be entitled to say as well, I think, this isn't in your own client's particular instance.
Yeah.
A question of having access to a car.
I was about to say.
It's being dependent on a
Yes,
car.
that's absolutely right. And as my Lord Justice Man was asking me his question, I was starting to reflect on that. So if we just go back to the sentence, it's about those who have access to a car. There's no recognition of dependence on a car, and no recognition then of the follow-on point.
So those who are dependent on the car are a subset of those who have access to a car.
Presumably. And then there may not be the Venn diagram may not fully align, but presumably. I mean, there may be people who, you can't, no, I'm sorry, that must be right. You can't be dependent. You may well need, you can have a need which is not met, I suppose, is the only point I'm making. I may be overcomplicating things.
Well, if you were dependent but didn't have a car,
Yes.
and were in that position,
then
you wouldn't be
essentially
you wouldn't be travelling.
No.
I mean, that's another.
Yes,
I'm not saying that's an irrelevant consequence, but
No.
but certainly you're entitled to say on the face of the document, this is about those who've got access,
Yeah, this is
to a
about
car, which
got
will
access.
include those who
Yes.
depend on a car.
What it's not doing, in a sense, I mean, taking the point at a slightly higher level of generality, I mean, sure, it's saying, well, for people who don't have access to a car, the only times may increase. Of course, that's true for non-disabled people too.
Of course.
What it's not doing is recognising ways in which that can be a particular problem for disabled people, whether because of dependence or because of increased discomfort, or indeed for other reasons.
Well, the things that Ms. Sheakh refers to in
The
her
things
witness.
that my client refers to. Yeah. So, I mean, in a sense, it's, and no doubt for this reason, Mr. Mobb asked me to read it out, and as I was going to do in any event. It can be said, well, it's the beginning of the necessary analysis, but it's nothing like the end of it. It's a step in the right direction, and the council's thinking did somewhat develop, it's right to say, but only after the decision. I mean, the other point which we're going to come to is, in any event, this isn't looked at by the decision maker. Even this document isn't looked at. And of course, it's I've already made the point. It's a draft document. It's not purporting to be a final document. But unfortunately, there wasn't a final document which the decision maker had access to. So I deal with it because it's part of the picture, but I'm not going to say it.
Right.
So then the order is then made. The TTO for Railton is made on the 7th of August. That's paragraph 53 of the judgment. The next stage, again, I don't think we need to turn anything up for this, it's paragraph 54 of the judgment, is that the four oval, remember there's already a TTO in place, we now move to the making, not any decision, but just the making of the four oval triangle orders, and therefore of the oval triangle LTN. So that's on paragraph 50 or 16th of September. Now, what is striking about this is that it doesn't appear that a decision was made by anyone, certainly in the sense of a formal decision. Presumably at some level of informality, someone made a decision, but no formal decision made. Certainly it wasn't made by Mr. Sonmu to do so. And it's for that reason that in relation to oval triangle, Lambeth later conceded, as I think the judge records, paragraph 106, that the oval triangle LTN was unlawful. The ETOs underlying were unlawful because it just wasn't a decision at all. It's the most bald form of illegality. And so to that extent, the oval triangle orders plainly were unlawful. The difficulty, of course, is that no challenge was brought in relation to, I don't think my clients knew about it, no challenge was brought within the statutory 6 weeks, and so actually there's no relief.
Yeah, I mean, there might be questions about the consequences of breaching a requirement of the orders and what the sanction.
Indeed, and there may be I don't think it's a matter for you, but there might be there might be arguments that could be made on a enforcement penalty appeal and so forth about whether the. But I mean, those are quite deep waters.
The Boddington line?
That's right, exactly right. So I'm not inviting the court to get into it. It's not a matter for today.
No. Well, we won't go into that.
But there just wasn't any validating decision to accompany those orders, which is flatly unlawful. Now, unfortunately, I can't do anything about it, and as you know, I'm not asking for any quashing relief for that reason, even if I make out my additional point about the equality impact. But it's pretty unsatisfactory, you might think.
Yeah.
This isn't like Boddington, is it? Because I don't think there was an ouster provision in Boddington like the ouster provision in this case.
Don't.
But I mean,
there's no need. There's no need.
It's just I see a rabbit hole and I go.
All I'll say is that I've turned these points over in my mind a little bit.
Yeah. Let me withdraw
and I'd be very grateful if we could.
I'll withdraw my reference to to Boddington, which was...
Yes, but I mean, the point, it's right that, at any rate, one can see the shape of arguments that might be made in some other proceedings about this, but it's not a matter that need trouble the title. So, that's the oval triangle. So, oval triangle was made in that sense unlawful and without a validating decision. No one took account of any material factors, let alone the equality impacts. And then the judge continues to give some background information of that. The next significant point in the chronology, then, is the decision. This is the decision which gives rise, which validates all three of the low traffic neighbourhoods, albeit in relation to oval triangle, arguably not necessary or redundant. But and that is in the supplementary. That we should turn up. That is in the supplementary bundle at tab 11.
Tab 11.
And I'm going to use paragraph. Fortunately, we do have although my page numbers are going to be out, we can do it by sequential page.
Yeah. We've only got the bundle pagination.
Yes, but we've got paragraph numbers.
Paragraph numbers, yeah.
And that will do. I think that will do the job adequately.
Yes, it will.
So this is the decision, because this is the delegated decision taken by Mr. Sonmu. You can see that on the first page, who's the relevant strategic director to whom the power was delegated, to authorise the schemes, the various schemes, and you can see under recommendations. So, by the way, I'm not 100% sure about, but my understanding of the way this works is that analogously to a report to cabinet or something of that kind, this report was not written by Mr. We've never had an answer to this. This report wouldn't have been written by Mr. de Sonmu, but it's authorised, i.e. the decision is taken by him on the basis of the considerations set out. I think that's how it works.
Yeah.
But in a sense, it can be taken to be, in the absence of any indication of the contrary, to constitute the reasons for the decision on the one hand, in the ordinary way, if there's any dispute about this, and to demonstrate the extent of factors, relevant factors that were considered, including also, of course, equality implications, absent any evidence that goes any further. I should say we don't have any evidence, there's no evidence ever been filed from Mr. de Sonmu about his decision making. To supplement that, there is a witness statement from Mr. Phillips, but A, he's not in a position to say what was in Mr. de Sonmu's mind, and secondly, other than at any rate in relation to the broadest generalities, he doesn't do so. So, subject to Mr. Mould, I'm not going to take you to that.
No.
So this is it, in effect. This is the decision.
Yes.
So we should look at the way the report works, although there's obviously one critical section. So tab 11, you can see the recommendations are to approve the various schemes. That's on the first page, in the sort of summary section of it. Then 2 pages in, we've got a heading context, and from then on we've got the guide of the paragraph numbering to make up for the deficiency in my page numbering.
Can I just ask a question, which I perhaps ought to have asked earlier? We notice here at 1B in the recommendations, there was separate...
Sorry, you mean in relation to recommendations, yeah?
Yeah, sorry,
Yes.
Paragraph 1B in the
Yes.
recommendations. Separate LTNs for Railton and for St Matthews.
Yes.
Did they comprise ultimately a single...
Yes, effectively I think that's right. So
Was there contiguous areas?
they're contiguous areas, and they are effectively... I think I'm right in saying I was not going to turn up the actual underlying traffic orders because they're nightmarish documents.
You don't need to. No.
But effectively, they don't. It's not that you've got one set of orders for one and one set of orders
But
for the other.
is it wrong to refer to the Railton and St Matthews low traffic neighbourhood?
I think, certainly in terms of what we end up with, I think it's right. It's correct to do that. It's obvious that at certain points they were considered somewhat separately, and I think, let's just double check this. Yes, if you just turn up, if you go to, in the report, they're treated as separate matters. So Railton, Brixton, paragraph 2.13, Railton, Brixton, LTN is prescribed.
Yeah.
And then separately 2.26, St Matthews, Brixton, LTN is prescribed. But at some point after that, they're merged effectively in implementation. I don't take any point about
No.
it. But you might know, it's a helpful point to make.
I simply want to make sure that in the judgment
I understand.
we get this right.
Yeah, but that's correct.
So to one LTN.
There's one LTN, comprising one. Although there's more than one one ETO.
Yeah.
That's because the ETOs that are made
Yeah.
deal with different subjects, parking, routes, and so forth. Not because they don't differentiate by area. If that makes sense.
No, understood. Sorry to interrupt you.
No, not at all. I'm progressing. So my lords and my lady, if we then start just going into the report a little bit, there's a heading context, and there's no doubt. See paragraph 1.4 that what I've earlier described as the need for speed was present in the council's mind. As I say, see paragraph 1.4, and the judge so finds, and so far as it goes, I don't dispute it. But I simply say, and I'll develop this in due course, that can't affect the discharge of the duty on the facts of this case. So then you've got section 2, proposals and reasons, and the way this works is you've got some general introductory paragraphs, so 2.1 through to 2.5, which set out some slightly general considerations. I'll say something about them in just a moment. And then following on from that, you can see 2.5 says, the resultant traffic management proposals are described as follows, and then you get a fairly detailed description in 2.6 all the way through to the end of this section, 2.31, of various measures. But those bits of the report don't do anything, I think, more than describe, so it doesn't help us on what was taken into account. As to 2.1 to 2.4 then, there's I submitted below, and I didn't succeed, and I've not been given permission to renew it, so I just noted in passing, I submitted that this showed a failure to comply with other legal duties under section 122 of the RTRA. I haven't expressed that argument to you. But we should perhaps note briefly the limits of it, what it does do. So 2.1, lengthy, I won't read it all out. What it effectively does is contemplate two alternatives. One is LTNs. This is all to deal with the need identified in statutory guidance. One is LTNs on the one hand, and the alternative is changes to road layouts to assist with cycling. And that proposal is rejected for various reasons which are set out in the paragraph. So all but the last 4 lines of the paragraph effectively are dealing with why that doesn't work. Fine in itself, I make no criticism. And then consequently, is what's said at the 4th line from the end, consequently is recommended that rather than pursuing route-based traffic reduction, the council pursues LTNs, effectively is what it says. So the logic of the paragraph is we've got to do something. We can't do route-based, what's described as route-based traffic reduction. Therefore, we've got to do LTNs. Now, that's obviously a relevant matter, but it's a slightly unsatisfactory way of thinking about it because it begs the question of whether LTNs are themselves a good thing to do or any particular LTNs are a good thing to do. I'm not saying it's itself unlawful. For present purposes, the only important point that really matters is that what it's plainly not doing is getting into the merits of LTNs in terms of their equality conditions. 2.2 is about which. So the premise of 2.2 is we're going to do LTNs. Which ones shall we do and which ones shall we give priority to? So again, that doesn't really engage with any equality issue. 2.3 again comes back to this point about the speed of delivery and explains why they're going by the ETO route. Slightly loses sight of the fact they've already got TTOs in place for some of them, one might think, but there it is. And then 2.4 is a very particular point about emergency services. No doubt a valid point, but not one that takes it much further. And that is, in a sense, in my submission, the limit of the consideration in this document of the actual merits of the LTNs. I don't need to succeed in saying that, but it's certainly, if there's more, I suggest it's for Mr. Moll to identify. You then, as I say, get the various descriptions of the schemes. I don't need to go through that in any detail. We get, then going through the report, we go on to section 3. It's about finance, obviously important, but not terribly germane to us.
There is throughout section 2 express recognition that the effect of the LTNs is that traffic will increase on roads outside the LTNs.
Yes.
I mean, it's a statement.
To that extent.
Statement,
Yeah,
obvious,
to that
but it is there.
Yes, okay. But yes, I don't go so far as to say that there was nothing of that sort. I might think there's not very much, but there it is. Anyway, that's still again not about equality, which is the only point that matters to me. Section 3, as I say, is about finance. Obviously, a very important matter for the council, but not germane to the issues we need to look at. Section 4, mirroring what I showed you. This is really why I showed it to you in the May 2020 report, then sets out again a series of relevant legal duties, including the PSED, and the PSED is dealt with quite far on, so it's paragraphs 4.16 and 4.17. I don't know if it matters, it's actually dealt with slightly more shortly by comparison with the May 2020 report, but there it is.
But again, you don't take issue with the...
I don't take issue with what's said.
No.
What I do say is it doesn't constitute
No.
an application of the duty or a discharge of the duty. It's just just describing the legal duty.
Yeah.
Section 5 is consultation. Explains effectively why consultation not required as an ETO. So far as it goes, correct, but it doesn't take us any further. Section 6 is risk management. I mean, it's a slightly curious, I suggest, section. It's identified, it's rather sort of, dare I say, it's a bit tick boxy, but section 6.1, the main risks associated with the proposals, details in this report are summarised in the table below, and then there's a sort of key to the table, and then certain points are noticed. Noted and likelihood impacts are given a score. I suggest that doesn't really take us any further in terms of quality impact. If someone says if Mr. Moll says differently, he'll no doubt develop it. And then we get to what is the absolute critical passage in this case, which is at section 7. Section 7, equalities impact assessment. I hope you'll forgive me for just reading this out, given what I've just said.
Good.
A separate equalities impact assessment has not been completed for this decision, but prior to making the recommendations detailed in this report, regard has been given to the public sector equality duty and the relevant protected characteristics. So, in itself, it's not fatal, of course, that an assessment hasn't been carried out. I completely accept that, but it's noting that none has been carried out. I don't understand the sense in which the next bit in that paragraph. So, regard has been given to the PSED. By whom, one might ask? Bearing in mind, certainly as I understand it, that Mr. Sommer is not the author of this report, not it appears by him, which is the only point that matters.
But paragraph 7.2.
Well, I'm going to come to...
Right.
Sorry, I was going to come straight to that next. So, similarly, paragraph 7.2. The assistant director, so that's not the decision maker, remember, that's not the delegate. Yeah. The assistant director for highways, etc., has approved the project team's assessment. So I take it the assistant director is not the author of the report. I may be wrong about that, but I don't understand that to be the case. I think it is a she. She is certainly not the decision maker. She has approved the project team's assessment. There's a reasonable expectation that the measures will not disproportionately affect people and so forth. The veracity of this conclusion will be explored as part of the 6-month post-implementation consultation period. So what the decision maker is being told, or if he is the author, is recording, but I don't think he is that someone else has approved the project team's assessment. At a very high, and certainly the way the conclusion is described is it's put at a very high level.
But there's no indication of any disagreement with that view. I'm simply noting, as a matter of fact, that there isn't.
No.
And the next is a question, I think. Would one not have expected the author of this report to have identified a disagreement?
Well, if there was a disagreement, they would have identified the disagreement. That's right.
Right.
They ought to have done. I'm not suggesting there is a disagreement.
No.
No, it's not part of my case. There wasn't.
It's a short step, isn't it, or is it? not a short step from that to the proposition that this was the view of the decision maker?
No, because the decision maker is not being invited to or given any material upon which to form his own view.
Well, with respect, he was. The decision maker was being told that the assistant director of highways, etc., had approved the project team's assessment.
Well, lady, that brings us. I mean, I'm going to come to the authorities, but my simple submission is that isn't on clear authority. Is not adequate, because that amounts to a delegation by the decision maker to the decision of someone else, or simply adopting without any independent analysis the decision that someone else has reached. What the authorities show very clearly is that the decision maker, so Mr. Disonmu here, I'll come to it in the authorities, but the decision maker has to be appraised of the relevant considerations themselves and reach a view upon them.
Wow.
What this is saying, what the decision maker is simply being told that someone else is satisfied about it, so you, decision maker, needn't take the matter any further. And that, in my respectful submission, is not lawful.
Well, let's
We'll
see what we get out of the
when we get to the
authorities.
authorities, of course. But and I'm going to come back, because this is a critical passage. I'm going to have to come back to this passage in any event when we get to the closing submission, my closing submissions.
Yes.
I won't be coming back to anything else, but I will be coming back to this.
No, understood.
So perhaps with that in mind, I'll park this for now. I won't read it out, but you can see paragraph 7.3 suggests doesn't take it any further forwards. It's not really about equality. I will just make this point, though. This is certainly not condescending to any kind of detail about particular protected characteristics. So, disability is mentioned in a list, in a parenthesis in paragraph 7.1, along with what I think may be all, or certainly most, of the other relevant protected characteristics to which section 149 relates. But there's no, as it were, substantive consideration here of the issues relating to disability or indeed any other protected characteristic. I'm focusing on disability because of the nature of my client's characteristics and because that may be a particularly perfect one for this kind of decision, but actually the point can be made in relation to all of the other as well. Anyway, I'll come back to that, but no analysis at all, in other words, of what the equality implications are, and nothing which this decision maker would be entitled, would enable this decision maker to undertake the analysis. And then that's it. Then you've got community safety and organisational implications, which I don't think take us any further. And then the decision is authorised. So this is the authorisation for all three of the schemes we're concerned with, and indeed for a number of other schemes that aren't before the court at the moment.
Can I ask, before, are we
Yes.
about to leave this?
We're about to leave the document. Let's not ask questions.
Then, just before we do, can I bring you back to a question about the status of the orders being made?
Yes.
They are experimental orders.
Yes.
Where do we get that explicit context in the report? Where is the nature of the decision?
So certainly.
Described.
That's a good question.
The report summary describes a series of experimental measures proposed to create
I'm grateful.
LTNs.
That's right.
Yeah, so
I mean, whether that's quite spelling out their experimental orders under Section 9 query, but I mean, it's certainly in that territory. I mean, I haven't taken a point that's not been recognised.
No. But it's simply to tie, because of course we have to read the whole document
No, sure.
as
And
a
then
piece.
paragraph 2.3 ties in the speed of delivery demanded by the guidance with the decision officer's view that
Yes, there we go.
introducing
I-
interventions by an ETOs and most appropriate.
I'd gone to that paragraph and then come back to it.
Sorry, paragraph 2.
2.3.
3, yes.
2.1.
Yeah, thank you.
Yeah.
Well, whilst your lordships are making a note on this, your lordships might also find 5.1 on page 242.
Yes. in other words, making the point in this context that the reason why consultation is not required is precisely for this experimental scheme.
Yes.
So I haven't submitted.
Yeah.
They
I
weren't
mean,
aware of that.
there's no dispute, nor could there be, I imagine, that one looks at the whole document.
Yeah. Yeah, that's right. And for what it's worth, I mean, I suppose on one level it's implicit in 7.2 as well, to this extent,
Yes.
which is the point that Mr. Mould made. But let me make it for him. So,
Yes,
final
yes.
sentence, the veracity of the
Yeah.
conclusion. I mean, it's not spelling it out, but in the context, that of course is Mr. Mould's key point. He says, well, whether or not this would have been an adequate discharge in a different context, it is an adequate discharge because these are experimental schemes and they're going to be kept under review, I say, and I'll come to it.
Yeah, and paragraph 5.2 spells out that there's
Yes.
going to be
You
a
could
6-month period
exactly. Well,
during
yeah.
which there will be formal public consultation.
So, I mean, to that extent, I perfectly recognise that context was sufficiently in the report. So that is what I want to say about that document for now. As I say, it may be the one document I want to come back to, but that's it for now.
Right.
So picking up the chronology and hopefully relatively quickly from here on in, because of course by this stage the decision's now been made.
Yes.
Sorry, I have to find where I am in my notes. Yeah, so that was the 9th of October. The judge tells us, paragraph 68, that the Streatham Hill ETOs were then made on the 14th of October.
68.
Paragraph 68.
Yeah.
Then, and that he explains that in the following paragraphs. Then, paragraph 71, we've got another draft. Remember, the only EQIA draft or otherwise that we've seen so far is in relation to Railton. So, for the first time, a draft EQIA is completed on the 21st of October, so long up now, well, long might be overstated, but significantly at any rate, after the relevant decision has been taken. And in my submission, I won't take you to it, we'll look at one more EQI, but they're all very similar, so it's not going to be helpful to look at each of them. In my submission, it's important to note, again, this is a draft EQIA, so I take it that it's the same point as before. I don't think, but I'm happy to be corrected on this, that it's even signed off by the relevant project team leader. At any rate, there is no evidence, and it is not suggested, that it's ever shown to Mr. Tassomba. In fact, there's no suggestion that he has any further role in decision-making or review of these schemes. So, in a sense, for that reason, I say that, albeit that, except that as we get later and later iterations of the EQI, you do get a little bit more and a little bit more in them. So that's irrelevant because they're not before the decision maker. They're just being held with. So far as one can tell, they're just being held within the project. So that's 21 October. That's for paragraph 71 of the judgment. That's oval triangle. I think it's the same day. Yes, paragraph 73. You get sign off for a similar document for Streatham Hill. As the judge notes, second sentence of paragraph 73, its content was materially the same.
The difference in the draft seems to be that whereas the first one you showed us talked about those who have access to a car, it's now expanded to include those who rely on taxis or carers.
Yes, there is an expansion, I accept that. What I was going to do, because, as I say, there's a lot of iterations of these, I'll just briefly take to the last one in the series, and you can see it's not all in one go, because otherwise I don't think it's necessary to go through each one.
I'm sure that's right.
So, my lord, so that's signed off. Then paragraph 77, we've got the second Railton EQIA. And paragraph 79, an update of the oval Triangle and Streatham Hill EQIA, sorry, that's paragraph 79 and 80. And perhaps that is a convenient moment just to take, I think this is the last of the series, but anyway, so if we go to tab 6, well, we'll just go to the last one. Perhaps tab 18. Yeah, this is the tab 18, sorry, I should have said supplementary bundle. So I think this is the last, yes it is, the last of the, chronologically speaking, the ETOs. This is the 1 December document. As you can see at the first page of the tab. So, updated document format, you see in version 112, updated document format and added information about exemption policy. And just to see how it's taken forward slightly, you then go, I'm sorry I don't have page numbers.
Well, it starts at 305.
I'm grateful. Is that the impacts by group heading?
No, sorry, the document starts.
Sorry, I'm so sorry, 305, right. So
311.
Yeah, 311.
311.
All right.
Very grateful.
So that's where you want us to go.
So what I should simply show you is how disability is dealt with now, and I freely accept what my lord made to me a moment ago, that there is an expansion. So 311. For those that do, I think the first bit is identical to the first part of the equivalent paragraph in the earlier document. There's then a new paragraph. For those that do have access to a car or rely on taxis or carriers, in some cases journey times may be increased for some trips, different routes might be needed. And then feedback gathered since the trial scheme was launched indicates some individuals have had to change their routes to access essential services and support. And going, I don't want to read out the whole thing, but if we go down 3 lines from the bottom, we have received feedback from disabled people who rely on motorised transport. So now you've got the concept of reliance. Yeah. And from SEND providers about the impact the LTN has had on their journeys. Further data is being collected. So even now they're not saying we've sufficiently done the job. That's significant in this regard in my submission. Because what Mr. Mould says is, well look, these are all, I don't inaccurately encapsulate his submission. He says, well look, what's important here is that these are all experimental schemes. So we're going to make the order, and then we're going to see how it works out. Now, in relation to matters such as whether it does indeed increase traffic on particular roads, one could see why that's a desirable aspect of the experiment. You can see that actually you may just not know, at any rate fully, how putting LTNs in one place will affect road, to the extent to which there's certainly an aspiration that in the long term it will reduce traffic on neighbouring roads rather than increase them because people will change their habits. Who knows? That's the benefit of it.
I mean, that's a factor which is expressly identified in the decision.
Oh, it is.
It talks about the inherent uncertainty of what will happen.
Absolutely. And so far as it goes, it's a fair point. I don't. But in terms of engaging with the basic point about the reliance on that disabled people may place on motorised transport, in my submission, you don't need to wait for the experiment to do that. That's something you can do and should do in advance. Because then you have an apprehension of the scope of the problem, the number of people affected, the degree of impact upon them and so forth. And what you don't see in these, certainly in the earlier EQIs, and even only green shoots as it were in the later, is a recognition of the basic problem that may arise for disabled people, the nature of their reliance and so forth. That's what in my submission, I mean, on one level this is irrelevant because none of this was before Mr. Somley, so my primary point is simply it wasn't before him, so it doesn't matter. But in my submission, in terms of complying with the Thameside duty, which I want, what one should expect, what one would expect, is an engagement with disabled people in advance to understand the nature of the impacts and the nature that may arise for them, the nature of their reliance on particular forms of transport, and so on. So even if you can't then fully work out what the impact going to be reduced or increased and so forth, you can start to think about, well, is it legitimate to conduct the experiment? Should we make exemptions right from the outset? All those sorts of things. And none of that is in my speech.
So when you say engagement with disabled people, what do you mean in practice? What should the council have done in practice?
Well, it could have engaged, for example, with a representative organisation. It did do so in one respect. Well, in fact, maybe it's sensible to go to... No, I'll go to that in just a moment.
Well, that's the cycling organisation.
That's the cycling organisation.
Yeah.
But it doesn't engage with any other organisation, whereas there was, and there's a witness statement, there's another organisation with whom it could have engaged.
But isn't the real question how many people there are in each of the affected areas?
Very important, I agree.
But how would they find that out?
Well, I don't know the answer in the sense of knowing exactly how it's done, but I don't understand it to be said that that's not I don't think it's a particularly difficult task. I mean, there are censuses, there are all sorts of records relating to disability that the council will have access to, and it can carry out.
Well, the census information will be quite old, won't it?
Yes, I'm not sure. But well, I mean, this point hasn't arisen, but so far.
No, I'm just
No, I understand, but I'm sorry, I'm not trying to be
unhelpful. The heart
unhelpful.
of your submission is that the council didn't do enough before it made the ETOs or the TTOs.
Well, Milady, because the point hasn't arisen, I
just want to explore
Yes.
what it is in practice that they could have done and didn't do.
So, my lady,
should have done.
Although I don't have chapter and verse to hand, first of all, I'm aware from other cases of certain forms of record that local authorities will have. For example, they're required, I think I've got this right, I don't want to overstate my certainty, they're required to maintain lists of, for example, blind people in their area. I'll check the details of that. They can engage with people on an individual basis, they can carry out education measures, they can carry out consultation. I accept they're not required to under the statutory scheme, I've shown you that. But that doesn't preclude the need to do so by virtue of the public quality duty. We'll see that.
Well, when you say engage with people on an individual level, what do you mean? Go round door to door, putting a thing through a letterbox saying, do you have a disability?
Questionnaires. No, you don't have to knock on doors necessarily. You can put out questionnaires. I mean, all sorts of measures of consultation are available to.
But isn't it obvious that there will be some disabled people who will be adversely impacted by the no traffic neighbourhoods, those, for example, in your client's position, but likewise there will be other disabled people who will benefit.
Well,
The cyclists.
It may or may not be obvious to your lordship, or indeed to me.
Well,
but only one side of that is reflected.
But what is very difficult to predict in advance is any quantification of that. That all depends on what the traffic does. It all depends on what impact on air quality the changes actually have, and nobody can really know that.
I accept it.
And the council has to, as it were, take all these factors into account. Once it's got the data, it may decide, well, we very much regret the impact on some disabled people, but the overall benefits are such that we're still going to go ahead. Or it may reach a different decision. Until it's got the data as a result of the experiment, assuming it's monitoring it properly, it's very hard for it to do anything other than at a very high level, isn't it?
So, my lord, I accept that there are certain things which you may be overstating, I think, saying possible. It may be difficult to work out without doing the experiment. So, as my lord says, impact on air pollution, quite the extent to which traffic on particular roads is increased and matters of that kind. That's right. And the point I was making earlier.
I mean, if it needed to know, for example, as I think you were suggesting in response to my lady, that the council ought to have found out how many disabled people would be adversely affected, it could equally be said that it should find out how many disabled people should be beneficially affected.
Well, I mean, I have no difficulty.
And that puts a very
I have no
burden
difficulty
on it, simply to have due regard on your case.
My lord, I mean, in my submission, some sense, I mean, I don't need to because he didn't do it. It'd be, I think, it had to work out the exact numbers of people affected. Certainly in the Railton decision, there's no reflection. Sorry, I said the Railton decision. I should have said the first EQI, the Railton 8 EQIA. As we've explored, there's no reflection even of the possibility of the problem in my submission beyond that single sentence about people who have access to a car, but not, as I point out, the problem that some of them may be actually reliant on cars or more deeply affected or whatever. So you don't get into numbers because you don't get into the possibility that there may be anyone. It's not for me. It's not for me, and it's not a problem faced by claimants in this case. It's not for me to specify. Well, you should have done X, Y, and Z. You should have done precisely this, because Mr. Mould will say perfectly legitimately, well, actually, it's not. The question for the court is whether it's adequate, not whether. Yeah, not for me to tell you exactly what they should have done.
This goes back. Yeah, I'm so sorry. Do finish.
I'm so sorry. I think
just say it again so that I've heard what you wanted to say.
There are limits to what I can do in the position of a claimant in this kind of case, and saying, well, you have to do X, Y, and Z. The task is to analyse whether what has been done is adequate, not what should have done. Because the council will always be able to say, if one commits oneself saying, well, they should have done this or they should have done that, the council will always say, well, actually, we could have done it a different way, and they may be right. So the question for the court is adequacy of what has been done, not exactly. And as I say, one is always specifying what else should that's precisely this.
Well, the ultimate question is: did the council have due regard to the listed equality objectives?
I accept that.
I was just going to take you back to the contextual point about the experiment.
Yes.
Which, in a sense, underlies all of these questions, I think. The nature of the experiment was to see how this would work in practice. Is that a fair characterisation?
I think so, yes.
If you do this to the network, what will happen? And of course, you can, we all know, you can do modelling to a degree.
And it's not perfect.
But
and,
what might be said to be the best evidence is the empirical evidence.
Yes.
How the network actually operates when you change it.
Yes.
By intervention.
I accept that.
So the nature of the experiment was to explore that.
Yes.
Would this produce the desired outcome? Namely, effectively a redistribution of vehicle traffic, principally.
Yes.
To alleviate environmental conditions in particular neighbourhoods.
Yes.
That really was what it was all about. So that's the frame, if you like, in which the whole conversation here takes place.
Correct.
Yeah.
Well, my lord, it does. I accept that, and I accept, of course, and I really is thought to be denied. Plainly, the experimental context is part of the context, and unlike the government guidance, I even go so far as it's quite an important part of the context.
Yes.
But the fact that you're conducting an experiment doesn't preclude the need to analyse to the best of your ability what you can analyse and what conclusion you can reach. And after all, they do that. And in a sense, that's implicit in the whole process, because if you're unable to reach any conclusions about the effect of the experiment, you wouldn't be doing it in the first place. You've got an expectation about how it will work. And what section... You've got an expectation or a hope or an aspiration that it will, in fact, in the long term, reduce traffic flows and change traffic flows in ways that are beneficial and so forth. But and just as you can predict, not with perfect certainty, but to a degree, those effects, so you must be able to predict, not with perfect certainty, but to a degree, the nature of the problem. And one can see that, for example, in relation to journey times. Just take that as an example, because there are two impacts on journey times that my client describes. One is that the general levels of congestion are higher. Now, Lambeth would say, actually, they may say, we don't accept that. That's not a matter for the court to decide. Or they may say, well, they may be, I think there's a suggestion that you get a kind of increase at the start, and then actually as people's habits change, you get a benefit. So they can say all of that, that's fine. That's the purpose of the experiment. But another reason journey times increase is because you can't drive through particular areas. And that, with respect, is much more predictable. And for someone like my client, for example, I mean, I made the point in the skeleton, but she lives just outside, she and no doubt many other people with those sorts of protected characteristics, live just outside a particular LTN. her cul-de-sac goes onto a main road. The main road, prior to the LTNs, she goes left or right depending on where she's going. As it now is, if she goes left, she just hits the LTN and she can't progress further. So she now always, without exception, has to drive right round. Now that sort of thing, you don't really need the experiment to see that for that category of person, you're going to increase journey times and that will have knock-on effects.
Well, assuming that you can predict what the impact will be on that part of the unrestricted network.
Well, yeah, unless the improvements are so great, but I don't think anyone's that even though you've got to drive.
What you're entitled to say, I think, that you can make a fair stab at predicting what the impacts might be.
Exactly.
That's the point you're making.
That's the point. And the fact what in effect you get here, certainly in Mr. Disonmi's decision, is we can't. What it amounts to is we can't do any of this, so we'll keep it under review. There's no consideration by him of these elements, none whatsoever. And insofar as there's any evidence of any consideration before the decision, it's limited to the 1.8 EQIA for Railton, which is a draft, not completed. It says itself further work to be done. And plainly further work did need to be done, and therefore it should have been done, and then it should have been taken account of by Mr. Disonmi. That's just because it's an experiment, you can't throw up your hands and say, well, we'll wait and see. What you can, I perfectly accept, is say, here's to borrow to use a hackneyed phrase, here's the known unknowns, here's the unknown unknowns. We've got some sense of the scope of the issues, and having regard to what we can and can't know, it's sensible to make the order and keep it under review. If you do that sort of thing, that might be different, but certainly on equalities impact, they don't do that. That's the submission. They just say, well, someone else has thought it's okay, and we'll keep it under review. That's all that Mr. Disonmi knows. Getting rather into my submissions here.
Well, no, but I mean, I think that's in the nature of
that's in the nature of
the hearing,
sometimes
isn't
it?
Questions
and, yeah, sure. And
no, of course, you can make your submissions in a freestanding way.
Yeah. So that's, I think, what I want to show you of that document. The one thing I should do then to complete the chronology is just briefly show you that then in relation specifically to Railton and St Matthews, but I'm just calling it Railton, there's a further decision or a further purported decision. That's in tab 15. Now, this was unlike the earlier one, I think accompanied by an EQIA for Railton. You can see that in paragraph 7.1 and 7.2. So perhaps we should just go to that. So 7.1 and 7.2 are the consideration of equalities in the report. It doesn't contain any substantive consideration, but it's right to say it does append the EQIA, which one assumes is the most recent EQIA for Railton.
Is the previous section relevant as well?
There's a slightly extended risk management. Well, can I answer that in a slightly more, because there's a critical point to make about this document. If we just go back to the first page.
Yeah.
So report title. So slightly curious, by the way, because where we are on Railton, remember, is we've got the necessary authorisation already. The order's not in place, but we've got the authorisation by virtue of the 9th October decision. I accept that in terms of the basic need for a delegated decision, that meets that, subject to equalities. So it's slightly curious why a further decision is being made on Railton. If you then note on the first page, report title, Railton, LTN, etc. Portfolio, that's just telling you the area. I think it's like it's in this department or in that department. Report authorised by, and that means who the decision maker is, Sandra Roebuck, Director of Infrastructure and Capital Delivery Resident Services. As I understand it, she is a person who sits below Mr. Dissonmu. She is not the person to whom authority to make the decision has been delegated by virtue of the 15th of May report. So the simple point about this is that it's not a decision made by Mr. Dissonmu or by anyone else who currently sits in his shoes. I don't think it's the case that he moved on and someone replaced him, but anyway, it's not made by the strategic director. And I think it's for that reason that, as I understand it, Mr. Mole doesn't invite him to take particular cognizance of it other than as, I think he can put it, part of the overall context. It's just not a decision by the relevant authorised officer.
Right.
And then just to complete the chronology, following on, in early January, the Railton St Matthews ETOs are made, paragraph 88 of the judgment, and I think that's on the 6th of January, yeah, paragraph 87.
Sorry, say that again. 6th of January.
6th of January, so we've got the distinction between the decisions to make and then the formal making of the order. So
yeah.
Remember the oval triangle is made in September. I've shown you that St Matthews is made on 14th, I think, of October. These ETOs don't come into force until the 6th of January for Railton. Of course, in relation to Railton, as with oval triangle, there were TTOs in place in the meantime.
Yeah.
Unlike for Streatham Hill.
Right. It might just be worth at some point recalling what the target of the claim
yes.
specifically was and is.
Yes.
Is it worth doing that now? Do you
Yeah,
think?
sure. Well, the target of the claim is quite simply the, I say, and I don't think there's any dispute about it, is the decision of the 9th of October. I mean, the formal target are the relevant ETOs. That's because that's what you challenge under the statutory.
Yes, but the decision under challenge.
The decision under challenge is the decision of the 9th of October, because that's the decision which authorises in all cases, and the only decision which authorises the various ETOs. And the submission, the ground of appeal, and therefore the ground of challenge, is simply that in taking that decision, the obligation to have due regard to equalities, implications, so forth, I'll come to the section in a minute, was not discharged.
Yeah.
Does that answer my Lord's question? I hope I've...
No, it does.
That's the question you were asking.
No, it does, precisely, yes.
Yes.
Thank you very much.
So with that in mind, the remainder of my submissions, I note that it's 10 to 1, but I don't anticipate I'm going to be very much longer, is
No.
the law, so we need to look at the authorities.
There's no pressure of time on you. You're going to go on to the law now.
Then it will be a matter of drawing the threads together.
And then draw the threads together with your submissions.
Yes.
How long do you need on the law?
I'll be slightly... I would have thought I'd be about 25 minutes on the law. And
Do you want to make a start now?
Yes, I think that's sensible.
All right, yes, we'll do that and then
So,
reach a point around 1 o'clock if you can. If you
yes.
go beyond
Well, it
that,
may be
it's
sensible. I think we ought to turn up section 149. I know you're very familiar with it. Let's do that, and that may be a section 149. So, section 149 is in tab 2 of the authorities. I know that I'm sure you're all going to be pretty familiar with this.
Yeah.
So
I think you can be sure of that.
Yes, well, let me take it pretty quickly. So, very familiar. Section 149, a public authority must, in the exercise of its functions, have due regard, this important phrase, due regard to the need to, when various aims are set out. They're all potentially in play, but I think B is most important to us, so let me focus on that. B, advance equality of opportunity between persons who share a relevant protected characteristic. So that introduces the idea of protected characteristics. We note, of course, that the protected characteristics in subsection 7 include disability. That's the one that I focus on for these purposes, the purpose of this claim. And then 3 is also worth noting. Having due regard to the need to advance equality, so this is expanding on what is meant by 1b, having due regard to the need to advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it, involves having due regard in particular to the need to, and then these are all potentially in play, but again I think A is probably the most useful to note. Remove or minimise disadvantage suffered by persons who share a relevant protected characteristic that are connected to that characteristic. And I say if it's not explicit, it must be implicit in that the recognition of the need to remove such disadvantage must include a recognition of the need not to increase disadvantage, which is, from my client's perspective, what we say is in play in this case. And so we say making of these orders occasion significant disadvantage to her and others with her characteristic in the way that I've set out, or in the way that I've earlier explained. I mean, that's all I wanted to say again about section 149 at this stage, unless there's any questions about it.
Yeah.
The next thing on the agenda is bracking, which will be more than 5 minutes.
All right.
Possibly not much more, so perhaps that's a
What?
moment.
Do you want to break now and come back to
I'm in the
bracking?
court's hands. I mean, I can start on bracking, but it might be sensible to start with bracking after lunch.
All right, well, we'll do that then, that's fine. Can I suggest that we start again at 5 to 2?
Yes, exactly. Yeah.
And we're not at any risk of failing to complete the hearing today?
I don't think so. I had optimistically expected to be done before lunch.
No.
I never, I never achieved my own optimistic
the only constraint is that we must, because we
Yes,
form different constitutions next week, and therefore we must.
I anticipate that I'll be about half an hour after lunch. If Mr. Mole thinks that's okay for him.
I'm going to try and say what I've got to say in no more than an hour.
All right, so we're in a good place so far as time is concerned.
Indeed.
All right, fine. Thank you. 5 to 2.
Okay.